You heard the evidence of Inspector Gianni. He was the one that led the operation. He was the one that detained and counted the money. Afterwards, he gave it over to the F.I.U, to the custody of the F.I.U. But that's not what, as it were, is the foundation for the originating application for continued seizure. The basis for that is that the person that seized it, or the branch of law enforcement that seized it, must show that it had a reasonable suspicion that allowed the seizure of the money, and must then convince the court that it is necessary to hold on to the money so that investigations might be completed. How the F.I.U. gets into it, when you look at the language in the appropriate section of the Money Laundering Act, absolutely defeats me. It can't be that because policemen are attached to the F.I.U., even though the police officers attached to the F.I.U. were not the ones that carried out the search and seizure, that simply because they have policemen attached to them, that they can continue or they can be the ones to move the application for the continued detention of what was seized, not by them, but by the Trafficking in Persons Unit. That is a fundamental issue, and I believe the magistrate is way wrong in saying that, oh, but in effect they're all part and parcel of law enforcement. No, there are different rules given by different pieces of legislation to different units. As I pointed out, the F.I.U. has, under its own act, the authority to do search and seizures and to move for the attachment of any monies they find in consequence of search and seizure. But this is not that.